Next time you crack open a can of Coke, ask yourself something: who actually knows what is in it? Because the honest answer is almost nobody. A handful of people on Earth. That recipe has been kept secret for over 100 years. And here is the strange part. Coca-Cola could have patented it, locked it down with the law, back in the 1800s. They said no. Turning down a patent means turning down the strongest protection an inventor can get. So why would the most famous drink on the planet refuse it? That is the curious part. For all that secrecy, Coca-Cola never patented its formula. Not once. The most famous product on Earth, invented back in the 19th century, was never protected the way you'd protect any big invention. And that wasn't an oversight. That was the whole point. So if you were sitting on the most valuable recipe on Earth, the obvious move would be to patent it. Lock it down. Make it legally yours. And to see why Coca-Cola did the opposite, you have to know what a patent actually is. A patent is not really a lock at all. It is a deal with the government. And like any deal, both sides give something up to get something in return. Here is your side of the bargain. You tell the government exactly how your invention works. Every step, every ingredient, every clever trick. You write it all down, and that document becomes public for anyone to read. In exchange, the government hands you a fence. For a set stretch of years, nobody else is allowed to make, use, or sell your invention without your say-so. You get to be the only one in the market. That is the whole trade. Secrecy for monopoly. You surrender the how, and the government protects the who. It is a genuinely elegant arrangement, and for most inventors, it is the right one. The state gets a public library of new ideas everyone can eventually build on. The inventor gets a head start nobody can steal. Everybody wins. Or almost everybody, because there is a catch buried in that little phrase, a set stretch of years. That trade, exclusivity for disclosure, sounds like a clean deal, but there's a string attached that most people never notice. The government doesn't hand you those exclusive rights forever. It rents them to you. Every patent runs on a clock. From the day it's granted, a countdown starts, and it lasts only a set number of years. During that stretch, you alone control the invention. Then the clock runs out. When it does, your protection doesn't quietly renew. It vanishes. The invention drops into what's called the public domain, a kind of shared shelf where anything can be picked up and used by anyone, free of charge. And here's the part that stings. Remember, you already published exactly how it works. The full recipe, the precise steps, all of it printed in that filing, years earlier. So the moment the clock stops, your competitors don't have to guess. They just read. So a patent isn't a fortress. It's a loan of exclusivity with a fixed repayment date, and the currency you pay back is the secret itself. For an inventor with a machine, that's a fine deal. For a company built on one guarded formula, it's a countdown to giving the whole thing away. So if that ticking clock is the price of a patent, you can start to see why a certain company in Atlanta might have wanted nothing to do with it. And the story of why begins not with a lawyer, but with a pharmacist and a headache. In the late 19th century, a druggist named John Stith Pemberton was mixing tonics in Atlanta, Georgia. He wasn't trying to invent a soft drink. He was trying to invent a medicine, the kind a pharmacist could sell across a counter. This was the golden age of the patent medicine. Bottled cures promising to fix everything from fatigue to nervous exhaustion lined every drugstore. Pemberton's syrup was pitched as one more remedy in that crowd, a pick-me-up for the tired and the aching. There was another angle, too. Temperance was sweeping the country, and alcohol was falling out of favor in much of the South. So Pemberton leaned into it, selling his drink as the sober alternative, a tonic that could lift your spirits without a drop of liquor in it. And what actually went into that first syrup? Sugar and water, of course. A caffeine kick pulled from the cola nut. And an extract taken from the leaves of the coca plant, blended together into a dark, sweet concentrate. That coca leaf gave the drink half its name, and the cola nut the other half. 2 plants, 1 syrup, innocent enough on a soda fountain menu. But one of those ingredients carried something Pemberton could never have printed for the whole world to read. That patent medicine origin matters more than it sounds, because of what Pemberton actually poured into his syrup. The original recipe drew an extract from the coca leaf, the very same plant that gives us cocaine. And this was not a trace whisper of it. By most accounts, Pemberton called for around 5 ounces of coca leaf per gallon of syrup, a serious dose, back when nobody thought twice about selling it over a counter. Attitudes shifted over the years, and by most accounts, a successor named Asa Candler claimed his reworked formula carried only a fraction of that early amount. The recipe was quietly changing, but here is the deeper problem hiding in it. Remember the deal a patent demands. To get one, you must spell out exactly what your invention contains, line by line, for anyone to read. Every ingredient in its true proportion, printed in a public government file. So imagine a company being forced to publish, in permanent public record, that its wholesome fountain drink contained an extract of the coca leaf. A document like that does not just reveal a recipe. It hands critics a headline. A patent would have chained the company to the truth of its own ingredients forever, no matter how the world changed around it. Which raises the obvious question: if disclosure was such a trap, what other kind of protection could it possibly use? So if a public filing was the last thing a company like this would ever want, the natural question is what the alternative even looked like. Because the law offers a second door entirely, and it works on the exact opposite logic. A patent, remember, is a trade. You hand over every detail in exchange for a fixed stretch of protection. The trade secret asks for none of that. No disclosure, no filing, no fee paid to any government office at all. You do not walk into a patent office and register anything. You simply keep your mouth shut. The protection turns on one condition, and one condition only. The secret has to stay secret. And here is where the two paths really split. A patent runs on a clock. A trade secret has no clock at all. There is no expiration date written anywhere, because nobody ever wrote the thing down for the public in the first place. Protection that never expires, as long as confidentiality holds. That is the whole bargain. Not 20 years, not 50, indefinitely. A secret kept perfectly could, in principle, outlive its inventor by centuries. So for a formula the makers never intended to reveal anyway, this door offered something a patent never could: not stronger protection. Not cheaper protection. Protection with no ending. But that promise comes with a string attached, and that catch is strict. The law does not hand you a trade secret for free. It only shields something you are genuinely working to keep hidden. Courts phrase it as a single test. To claim a secret, the owner has to take what they call reasonable measures to keep the information confidential. Leave it lying around, and you lose the right to call it secret at all. So the effort is not optional decoration. It is the entrance fee. A company that shrugs and lets its recipe circulate freely cannot then run to a courtroom and demand the secret be treated as protected property, which recasts everything about that Atlanta vault. The steel door, the guarded chamber, the stories of a formula locked away where almost no one can reach it. It looks like pure spectacle. It is also doing quiet legal work. Every visible barrier is evidence. The vault says, in the language a court understands, that this owner treated the information as precious and worked hard to keep it hidden. The theater and the legal proof are the same object, which means the secrecy was never just about hiding the taste of a soft drink. It was about building an unbroken record of guardianship, so that the moment anyone challenged the claim, the walls themselves would testify on the company's behalf. So the vault and the ritual are doing real legal work. But step back and ask the question that actually decides everything. Which path lets the company hold the recipe longer? Because that is a math problem, and the math is not close. Picture the patent route for Coca-Cola. Pemberton files, the recipe gets printed for the world, and the clock starts ticking. A couple of decades pass, the protection lapses, and the exact syrup drops into the public domain. From that moment, anyone could brew an identical drink and sell it legally. Every rival on the shelf gets the finished blueprint, free of charge, handed to them by the very filing meant to protect it. That is the deal a patent strikes. Now run the trade secret route. Nothing gets printed. No clock starts. There is no expiration date waiting at the end of some fixed number of years, because a secret that stays secret carries no deadline at all. So line up the two timelines side by side. The patent version would have expired within the lifetime of the people who invented it. The trade secret version, invented back in the late 19th century by John Stith Pemberton, is still holding well over 100 years later. One path buys you a few decades and then hands your recipe to everyone. The other buys you forever, as long as you keep quiet. When you frame the choice that plainly, the surprising decision starts to look like the only sensible one. So holding a secret for well over a century sounds like the whole win. But here is the quieter truth underneath it. The recipe was never really where the money lived. The syrup was almost the least valuable thing the company owned. Think of what you actually buy when you buy one. Sugar, water, flavoring, a little caffeine. The physical stuff costs a fraction of what you pay. Any competent chemist could brew something close in an afternoon. And plenty did. Store-brand colas have chased the taste for decades, some of them genuinely close. Yet the company kept selling the real one at a premium the copies could never touch. If the flavor were the moat, that gap makes no sense. What people were paying for lived somewhere else entirely. The red, the script, the feeling that this particular bottle meant something a knockoff couldn't. And behind that, a distribution machine that put it within arm's reach of nearly everyone on Earth. That is the real asset, and none of it lives in the formula. You can't reverse engineer 100 years of trust from a bottle. You can't copy a shelf in every corner shop on the planet by reading a list of ingredients. So the secrecy was doing something cleverer than guarding chemistry. It guarded the story. A mysterious formula, locked away and never shown, made the drink feel singular in a way no ingredient list ever could. The mystery itself was part of the product. Once you accept that the story matters more than the syrup, the company's most famous piece of theater starts to look less like theater. For years, Coca-Cola has told the world that only a tiny handful of people alive know the complete formula. And it goes further than that. By most accounts, no single executive holds the whole recipe. Each one is trusted with only a fragment, a separate piece of the puzzle, so that no one person could ever walk out the door carrying the entire thing in their head. It is a wonderful piece of mystique. It sounds like something out of a spy film, but strip away the romance, and you find something surprisingly practical hiding underneath. Splitting the knowledge is how you shrink the risk. If the full formula lived in one person's memory, one person could sell it, leak it, or lose it. Divide it among a few, and no single betrayal spills the whole secret. So the legend does two jobs at once. It builds a story customers can feel every time they crack open a can. And quietly, it functions as a genuine security system, one made of trust and fragments rather than walls. Which raises an obvious question the company can never fully answer. A patent is guarded by law, but a secret held in a few human minds is only ever as strong as the people keeping it, and the world outside is always trying to guess. But splitting the recipe among a trusted few only guards against one kind of leak, it stops someone inside from walking out the door with the whole thing. It does absolutely nothing about the person who never needed the vault at all. Here's the soft underbelly of the whole approach. A patent gives you a legal weapon against anyone who copies your invention, even if they figured it out completely on their own. A trade secret gives you no such weapon. If a rival chemist tinkers in a lab and independently lands on the same formula, the law shrugs. They broke no secret. They stole nothing. The moment someone reaches the answer on their own, your protection quietly evaporates. The same is true for reverse engineering. Buy the product, take it apart, work backward to how it was made, and if you did it honestly, you are free to use what you learn. A secret protects you only until someone else works it out fairly. Which is why, over the years, so many versions of the real Coca-Cola formula have surfaced. Old notebooks, chemical breakdowns, recipes each swearing they are the genuine article printed for anyone to read. And notice how the company reacts. It does not sue the publishers into silence. It cannot. Instead, it simply says none of them are quite right. Because against a leaked guess, mystery is the only defense a secret has left. So if a secret this famous survives on discipline rather than paperwork, you would expect Coca-Cola to be a lonely oddity. It isn't. Once you know what to look for, the same quiet choice shows up all over the shelf. Kentucky Fried Chicken built an entire identity around a blend of 11 herbs and spices. By the company's own telling, the mix has never been patented, never printed for the public. It sits locked away, guarded like a rumor. The reasoning is identical. A patent on that spice blend would have run out long ago, and every rival fryer could copy it word for word. Silence, instead, keeps the mystery alive with no expiration date. You find the same logic beyond food entirely. Certain industrial processes, certain manufacturing methods, certain blends and coatings are never filed at all. The moment a method is disclosed on paper, the clock starts ticking down toward the day anyone may use it. So the Atlanta Vault was never a one-off quirk of one strange drink. It was an early, loud demonstration of a general principle. When a formula's whole worth is that no one else has it, the smartest protection is the one you never write down. So this trick was never really about one soda in Atlanta. It shows up wherever a company decides the smartest move is to disclose nothing at all, and simply hold its ground for as long as the silence lasts. And here is where the whole thing turns inside out. Coca-Cola did not skip the patent because it wanted to be mysterious. It stayed quiet because a patent would have been a clock, and silence had no clock at all. The company traded disclosure for permanence. Tell the world your recipe and own it for a while, or tell no one and hold it as long as you can keep the lid on. It picked forever, and forever it has been. That is the curious part. The most guarded formula on Earth is guarded so fiercely, precisely because it was never protected on paper. The vault, the ritual, the split knowledge, all of it exists because there is no filing standing behind it. So the next time a cold glass sweats in your hand, remember there is no expiring patent behind that taste. Just a secret, kept on purpose, for well over a century and counting. Everybody has one of these. Some price, some object, some everyday rule you walk past and quietly wonder about. Drop yours in the comments and subscribe so the next answer finds its way to you. Because there is always a reason why.